From the constitution of which of the following foreign country the idea of preamble was borrowed by the Indian Constitution? United States of America. Write the correct order of the word used in the preamble of the Constitution. Sovereign, socialist, secular, democratic, republic. How many times the preamble of Constitution has been amended so far? Once. Which one of the following liberties of the preamble of Constitution does not grant the liberty of practice of religion? Interpretative value of preamble was discussed in the case of Birubadi Union. The three types of justice referred in the preamble of Constitution are economic, political, and social. Which one of the following statement is correct? Preamble is a part of the Constitution and can be amended only if no change in the basic structure is made. The preamble of Indian Constitution aimed to secure dignity of the individual and unity and integrity of the nation. Which one of the following expression mentioned in the preamble to the Indian Constitution is correct? Liberty of thought, expression, belief, faith, and worship. Which one of the following expression mentioned in the preamble to the Indian Constitution is correct? Fraternity, assuring the dignity of individual and the unity integrity of the nation. Which one of the following cases did Supreme Court hold that preamble of the Constitution is a basic part of the structure? Is a part of the basic structure. S.R. Bommai versus Union of India. Which among the following words appeared first in the preamble of the Constitution of India? Justice. In which of the case Supreme Court gave a ruling that preamble was a part of the Constitution? Case 1 and Bharati case. The preamble of the Constitution of India first amended by Constitution 42nd Amendment 1976. The words secular and socialistic were added in the Indian Constitution in 1975 by amending the preamble. Legal sovereignty in India resides in the Constitution itself and not we the people of India. The ideology was expressed by Case 1 and Bharati case. The solemnity resolution in the preamble of our Constitution is made in the name of people of India. In which one of the following cases the Supreme Court held that the preamble is a part of the Constitution? Case 1 and Bharati case. Justice, social, economic and political. Liberty of thought, expression and belief. Equality of status and opportunity. Fraternity, assuring the dignity of the individual. Which one of the following statutes has no preamble? Government of India Act 1935. Considering the statement, the preamble of the Constitution of India can be amended by the Parliament up to any extent barring the basic feature. The preamble of Indian Constitution declared the resolve the people of India to secure to all its citizens liberty of belief, faith and worship. The preamble of the Constitution of India secured justice, liberty, equality and fraternity to all citizens. In Tinsukia Electric Company versus State of Assam, Supreme Court pointed out that the term socialist used in the preamble to the Constitution of India means the state whose basic policy to prohibit concentration of wealth and uplift the standard of people. Preamble of the Constitution of India include the source from which the Constitution derives its authority. Preamble of India is part of the Constitution and can be used in interpreting other provisions of the Constitution in case of ambiguity. A part of the preamble of the Constitution reads as we, the people of India, have been solemnly resolved to constitute India into sovereign socialist secular democratic republic. Certain words in the above part inserted by the Constitution 42nd Amendment 1976. The preamble of our Constitution is the extreme important and the Constitution should be read and interpreted in the light of the grand and novel vision expressed in the preamble. Justice Sikri expressed the above opinion in the case of Keswanand Bharti versus State of Kerala. One of the following articles describe the Republic of India as the Union, not the Federal, through the words are India, that is Bharat, shall be Union of India. Article 1. The the Parliament by law made alter the boundaries of state, provided that no bill for the purpose shall be introduced in either House of Parliament except on the recommendation of the President and unless the bill has been referred by the President to the legislature of the state for expressing its view thereon. The authority altered the boundaries of the state in India rests with Parliament. The power of Parliament to form a new state or to alter the area of boundaries is down with the Constitution other than Article 246. Under which article of the Constitution Parliament can create a new state? Article 3. Which of the following in India is empowered to admit the Union to establish new law? Parliament. Within the meaning of under Article 3, the Indian Constitution, the Parliament by law may form new state, alter the area of state, alter the boundaries of the names of existing state. Which one of the following is correct in relation of formation of new state from the territory of existing state? The Parliament may create a new state from the territory of existing state under Article 3 of the Constitution on the recommendation of the President, and if the bill for this purpose has been referred the legislature of the state affected for their view and the time period for receiving such view has expired. When the name of the state is changed or a new state is created, the Constitution of India is required to be amended by Parliament by simple majority as required under Article 107 and 108. The properties of a state government are acquired by the central government in accordance with the provision of the Act passed by the Parliament. The state challenges the central government action. Which one of the following is a best legal position? The action of the central government is valid because states are not sovereign. The Constitution is not federal in the nature of and contain adequate provision for acquisition of state property of the center under law. Which part of the Constitution define the various category of Indian citizen at the commencement of the Constitution? Part 2. Part 3 Fundamental Right, Article 12 to 35. Which one of the following does not fall within the meaning of state under Article 12 of the Indian Constitution? British Airway Corporation. Which will we fall? बैरकथल्ला विश्वविद्यालय भोपाल, गवर्नमेंट ऑफ इंडिया एंड द पार्लियामेंट, भोपाल म्युनिसिपल कॉर्पोरेशन. Which one of the following is not covered under the state of Article 12 of the Constitution? A deity. Which will be for central government, state government, University of Patna. Which one of the following is not a relevant factor to decide whether the agency or instrumentally should be treated as a state under Article 12 of the Constitution of India? Profit earning. Which one of the following is state within the definition of Article 12 of the Constitution? National Book Trust. A corporation of the state for the purpose of enforcement of fundamental right if it is the agency and instrumentally to the government. Which one of the following is not a state for the purpose of Article 12 of the Constitution? National Council of Education Research and Training NCRT. Which one is a nationalized bank? Institute of Medical Education Research Chandigarh, Ghaira Kalyan Kendra. Which one of the following is a state for the purpose of Article 12? Indian Oil Corporation. The 7-judge bench of the Supreme Court of India in Pradeep Kumar Viswas versus Indian Institute of Chemical Biology 2002 overruled its judgment in the case of Sabhyajit Tiwari. Which one of the following is correctly matched? Ajay Hasya Khalid Mujum Regional Engineering College run by a society as a state. P.K. Ramchandran Iyer versus Union of India. ICAR as state. Sabyajit Tiwari versus Union of India. CSRI as state. Tikkaraj versus Union of India. Institute of Constitutional and Parliamentary Studies is not a state. In which case, for the first time, the Supreme Court had laid down certain principles to decide as to when a corporation should to be an instrumental of the state. Ramanna Dayaram Sethi versus International Airport Authority of India. Point out the correct match. Satyajit Tiwari is related to state, not doctrine of eclipse. Rajasthan State Electric Board concept of state. G. Basi Reddy, Article 12. Bashir Nath, Fundamental Right. Article 12 of the Constitution defines state for the purpose of enforcement of fundamental right, against which one of the following institutions writ cannot be issued for enforcement of fundamental right. High Court. The definition of state under Article 12 of the Constitution is limited to Part 3 unless context otherwise required. Which one of the following is a state under Article 12 of the Indian Constitution for the purpose of enforcement of fundamental right? The Life Insurance Corporation of India. Which of the following is not a state under Article 12 of the Indian Constitution? National Council of Education Research and Training. The term state as mentioned in Article 12 of the Constitution of India includes Life Insurance Corporation of India. An electric board terminated the service of certain employee arbitrarily without giving notice. Which one of the following is alternate relative remedies can be best adopted by the concerned employee? The employee can move to the High Court by a writ of electric board is included within the definition of state. Under which one of the following article Law inconsistent or abridge fundamental right is declared as void. Article 13. The fundamental right can never be amended at as it beyond the purview of the Parliament. Such ruling was given in Golaknath versus State of Punjab. The objective of the Article 13 of the Constitution of India is secure paramountcy to the fundamental right. According to the Constitution of India, pre-constitutional law inconsistent with the fundamental rights are void. According to Article 13 of the Constitution of India, law includes any ordinance, order, bylaw, rules, regulation, notification, custom, uses having in the territory of India and force of law. Which one of the following is included in the definition of law provided in the Article 13? Bylaws, custom having force of law, using having the force of law. The term law in force in clause 3 of Article 13 means both A and B, only statutory law, customs and uses only. Clause 4 of Article 13 of Indian Constitution, which was inserted by 24 Amendment Act 1971, states that Constitution Amendment Act passes according to Article 368 of the Indian Constitution is a law within the meaning of Article 13 and would be accordingly void if the contravenes a fundamental right. This amendment was declared void in which of the following cases? Minerva Miles versus Union of India. A law abridges the fundamental right is not a nullity. It is only remain inoperative till the shadow of fundamental rights fall over it. This doctrine is known as doctrine of eclipse. Under the Constitution, doctrine of eclipse applies to all law, pre-constitutional and post-constitutional. In which one of the following cases did the Supreme Court held that an amendment of the Constitution under Article 368 was law within the meaning of Article 13 of the Constitution? Golaknath versus State of Punjab. The Supreme Court of India formulated the doctrine of eclipse in Bhakaji Narayan Dharkras versus State of Madhya Pradesh. Bhikaji. A law which abridges the fundamental right is not nullity but remain inoperative till the shadow of fundamental right fall over such right. This is known as doctrine of eclipse. Which one of the following cases are related to doctrine of eclipse? Deep Chand versus State of UP, State of Gujarat versus Ambika Miles, Dulre Lodi versus 3rd Additional District Judge. Doctrine of eclipse is regarded to Article 13. Doctrine of eclipse applied to all law pre-constitutional as well as post-constitutional. Law under Article 13(3)(a) of the Constitution include ordinance, order, notification, bylaw, rules, regulation, custom and uses having in territory of India the force of law. Which of the following article of Indian Constitution provide for power of judicial review and legislative function? Article 13. The leading case of doctrine of eclipse is Bhikaji versus MP. The ambiguity of the expression law as defined in Article 13(3)(a) of the Constitution of India ensured that paramountcy of the Constitution extend to the temporary law such as ordinance, notification, as well as permanent law such as act. In which one of the following cases was it was held that law made under Article 368 would be subject to Article 3 Clause 2 like other law. Goloknath versus State of Punjab. Under the Constitution, doctrine of eclipse applied to the all law pre-constitutional as post-constitutional. In which one of the following cases did the Supreme Court hold that an amendment of the Constitution under Article 368 was law within the meaning of Article 13? Goloknath versus State of Punjab. A law which disqualify a person within more than 2 children from holding the post of Panch Sarpanch is valid and not violative of Article 14 of the Constitution. In which of the following recent case Supreme Court gave such decision? Javed versus State of Haryana. Doctrine of waiver. Basir Nath versus CIT. Doctrine of eclipse. Bhikaji versus State of UP. Doctrine of severability. State of Bombay versus FN Balsara. Doctrine of repugnancy. Kesari Hind Private Limited versus NTC. The equity provision which Article 14 of the Constitution of India has been influenced by the Constitution of USA. Equity before law and equal protection of law under Article 14 available to both A and B, citizen and not citizen. The right of equity prevents the state from giving reservation to the public employment to the scheduled tribe irrespective of the consideration to efficiency of administration. Principle. The equality before law and equal protection of law means equals must be treated equal. All person is not equal by nature, attainment and circumstances. Article 14 does not encompass protection of life and liberty, which encompasses equality before law, equal protection of law, protection against arbitrary action. Select the right option based on the following assertion and reason. The principle of equality before law means that there should be equality of treatment under all equal circumstances. All persons are not equal by nature, attainment and circumstances. The right of equality before law contained in Article 14 of the Constitution of India available to all persons, whether natural and legal. The guiding principle of Article 14 is that all persons and things similarly circumstances shall be treated alike, both in respect of privilege conferred and liability imposed was held. Satish Chandra versus Union of India 1953. Give reason to the statement equality before law under Article 14 of the Constitution of India is with reference to law enacted by the legislature, executive order, etc. Discrimination by law in the marriageable year of boy 21 year and girl is 18 year does not offend the Article 14 of the Constitution. Article 14 of Indian Constitution does not prohibit reasonable classification. Which one of the following fundamental right is available to the both citizen and non-citizen? Right of equality before law. Equal protection of law in Article 14 has been taken from American Constitution. According to the Dicey, the meaning of the rule of law may be discussed under which one of the following head? Equality before law. Article 14 of the Constitution of India provided all persons equality before law and equal protection of law. All persons under Article 14 of the Constitution denote all company, association, or body of individual, both citizen and non-citizen, natural person and legal person. The Supreme Court of India has adopted a new approach for interpretation of the concept of equality in EP Rupaya versus State of Tamil Nadu. According to the new concept of equality, law cannot be arbitrary. The appointment of only lady principal or lady teacher in women college is not violative of Article 14. The Supreme Court decision in Sri Lekha Vidyarthi versus State of UP based on right of equality under Article 14 of the Constitution of India. The rule of law is found in Article 14. Article 14 confer on natural and just juristic principle. The equality provision with Article 14 of the Constitution of India has been influenced by the Constitution of the USA. The central government issued two notifications: liberalization pensionary benefit to civil servant and member of armed force retiring on their retiring on and after the prescribed date. The validity of the notification is challenged on the ground that it would violate the Article 14 of the Constitution. Which one of the following is correct? The notification are valid as they are rightly make any difference between civil servant and the member of armed force. The new concept of equality as an antithesis of arbitrariness was propounded first by the Supreme Court in which of the following cases? E.R. Rupaiya versus State of Tamil Nadu. Which one of the following fundamental rights is available to both citizen and alien? Right to equality. In which one of the following cases the new concept of doctrine of equality, protection against arbitrariness was propagated by Justice Bhagwati, E.P. Rupaiya versus State of Tamil Nadu? While interpreting the phrase equality before law contained in the Article 14 of the Constitution of India, the Supreme Court constantly maintained the equality means among equals, the laws should be equal and should be equally administered. It has been held by the Supreme Court that appointment of the candidate in excess of the notified vacancies, if denial was deprivation of the fundamental rights under Article 14, read with Article 16 of the Constitution in India, Ashok Kumar Chairman, Banking Service Recruitment Board. Give the correct response. Article 15 prohibits that articles shall not discriminate against any citizen on the ground only of the race, caste, sex, place of birth, any of them. In which one of the following Supreme Court cases it was held that no reservation under OBC category can be made to creamy layer for admission of educational institution? Ashok Kumar Thakur versus Union of India. Article 15 of the Constitution of India does not permit the state to make a special provision for any of the following. Which one is that? A class of a specific reason. Reservation of seat in educational institution in favor of scheduled caste and scheduled tribes governed by Article 15 Clause 4 of the Constitution. Which one of the following is the ground which is not mentioned in both Article 15 and Article 16 on which state cannot discriminate residents? The fundamental right is available only to the citizen of India. It is a right under Article 15. In which one of the following Supreme Court has declared Article 15 Clause 5 of the Constitution Ashok Kumar Thakur versus Union of India. Article 15 of the Constitution prohibits discrimination between citizens on the basis of religion, race, caste, sex, place of birth, any of them. The Supreme Court of India in one case observed that Article 15 Clause 4 enabling a person and the state government is the best judge to grant reservation for SC/ST backward class category at a post level in admission and decision, not to making any provision for reservation at the postgraduate level, suffering no infirmity. This observation was made by Justice S.H. Kapadia versus M. Naga in M. Nagarajan. In M. Nagaraj case, under which provision of the Constitution the reservation of 3 seats in the educational institution and public employment for physically challenged person is covered. Article 15 Clause 4. In which date the Supreme Court upheld the OBC quotas in central education institution, clearing the way of reservation 27% seat of the backward classes. 10th April 2008. Backwardness under Article 15 Clause 4 must be socially and educational. Fundamental right conferred by the Article 15 Clause 1 of the Constitution available to any citizen. Section 497 of IPC, which punishes only male participant in the offence of adultery and intravirus, in the view of which provision the Constitution of India, Article 15, Clause 3. Which one of the following is not correct about 93 constitutional amendment by which Article 15, Clause 5 inserted in the Constitution? The provision applicable to all educational institutions, including minority institutions, is wrong. Which one is right? State may make special provision for socially and educationally backward classes of the citizen of scheduled caste and scheduled tribes. This provision related to their admission in educational institution. The provision applied to all educational institutions, aided and unaided. In which recent case Supreme Court held that transgender fell in the category of socially and economically backward classes. Nalsa versus Union of India. The Right to Education Act make a mandatory for educational institutions to reserve 25% of seat for the children belonging to economic weaker section. However, this act is not applicable to aided or unaided minority school. Which one of the following amendment of the Constitution is related with the reservation in private education institution? 93rd Amendment. In which one of the following cases has Supreme Court upheld the constitutional validity of Constitution? 93 Amendment Act introducing Article 15 Clause 4. Ashok Kumar Thakur versus Union of India. 93rd Amendment in the Constitution of India deal with reservation for the administration in education policy. For which of the following can special provision can be made under Article 15 of the Constitution? Women and children, scheduled tribes, socially backward classes. Through which provision does the Constitution of India explicitly prohibit racial discrimination in India? Article 15 and 16. Article 15 Clause 3 of the Constitution of India empower the state to make special provision for women and children. Reservation of seat in educational institution in the favor of scheduled caste and scheduled tribes is governed by Article 15 Clause 5 of the Constitution. Which one of the following statement is correct in respect to state power of reservation in administrative education institution? Both caste and poverty are relevant criteria. The Supreme Court has ruled that person belonging to non-reserved class transplanted by the adoption or marriage or conservation of any voluntary act to the family belonging to reserved caste does not become eligible for the benefit of reservation, either under Article 15 Clause 4 and 16 Clause 4 of the Constitution. Kumari Madurai Patel versus Additional Commissioner Tribal Development. After which one of the following Supreme Court decision was special provision for socially and educationally backward classes introduced by Amendment Act of the Constitution? State of Madras versus Champakam Rajan. Equality of opportunity in the matter of public employment is granted to all the citizens of India. The catch-up rule established by the Supreme Court of India related to which one of the following article of the Constitution? Article 16, Clause 4A. By which one of the following Constitution amendment the Clause 4B was added to the Article 16 of the Constitution? 81st. In which one of the following cases Supreme Court held that Article 16 4A providing for reservation in promotion in enabling provision? M. Nagaraj versus Union of India. Which article of the Indian Constitution provides for reservation in the matter of promotion in service under the state in the favor of scheduled caste and scheduled tribes? Article 14, Clause 4A. Equality of opportunity in the matter of public employment is available to all citizens of India. According to the Supreme Court of India, Jat community of various states is not backward class under Article 16 Clause 4. In Indra Swani versus Union of India, the Supreme Court has held there cannot be reservation in the promotion. Under the law, certain posts are reserved for the residents of regional of the state on the ground that it was a backward area for compared to the other area of the state. The reservation is invalid as residential qualification cannot be prescribed by whole of the state and not a part of the state under Article 16 Clause 3. Article 16 Clause 1 of the Constitution of India incorporated the concept of equality of opportunity, in which case Supreme Court held that the rule that through reservation under Article 16 Clause 4 should not exceed 50%. It is not necessary to put out the consideration of certain extraordinary situations inherited in the great diversity of the country and the people. Indra Swani versus Union of India. Which one of the provision of the Constitution of India does not apply to the state of Jammu and Kashmir? Article 16 Clause 3. In which case the Supreme Court upheld the validity of constitutional amendment providing reservation in promotion to the certain category of person. M. Nagarajan versus Union of India. In which case has Supreme Court of India decided that reservation should be less than 50%. M. R. Balaji versus State of Mysore. Equality of opportunity in the matter of public employment is mentioned in which one of the following article? Article 16. By which Amendment Act Article 16 Clause 4A was added? 77th Amendment. Is it binding on the part of the state to make SC/ST reservation In the matter of promotion, no. Which provision of the Constitution gives the state authority to provide the reservation for appointment in the post in the service under the state in the favor of any backward classes citizen which in the opinion of the state it is adequate representation in the service under the state. Article 16 sub article 14 of the Constitution. In which one of the following judgment the Supreme Court directed that government of the Constitution is permanent body in the favor of backward classes? Indra Swani versus Union of India. Right to equality of opportunity in the matter of public employment is under constitutional right. Which article of the Constitution provided for the reservation in promotion for scheduled caste and scheduled tribes? Article 16 Clause 4A. In which one of the following cases the notification on 4th March 2014 regarding Jat reservation is set aside? Ram Singh versus Union of India. Under Article 14 Clause 4 relate to adequate representation. Which one of the following is correct about reservation in the public employment? Backward classes can be divided into backward and more backward category. In which case did the Supreme Court observe equality of opportunity, admit discrimination with the reason to prohibit discrimination without reason? State of Kerala versus N.M. Thomas. The right of equality prevents the state from giving reservation in public employment to scheduled tribes irrespective of any consideration if is to the administration. In which case Supreme Court has held that maximum limit of reservation cannot exceed 50%. Indra Swani versus Union of India. Which one of the following function does not require the consultation with the Public Service Commission as per prohibition of the Constitution of India? The manner in which any provision referred to Article 16 Clause 4 may made. As per provision of Article 16 Clause 4, the Constitution of India, for getting reservation for the appointment and post under the state, a class must be backward and should not be adequate representation in the service under the state. Which one of the following sections citizens should be excluded from benefit of reservation according to the principle of creamy layer as propounded by the Supreme Court in the Mandal Commission judgment, advanced section among other backward classes? After the judgment of the Supreme Court in Mandal case, it has been observed that the poisonous weed of casteism has been replanted where will trouble of the 1,000 year each age will have to consider it. This was observed by N.A. Palkiwala. Untouchability is abolished and the practice in any form forbidden under Article 17 of the Constitution. Practicing untouchability is violation of the constitutional right is a criminal offense. Which article of the Constitution of India outlaws the untouchability, make it punishable offense? Article 17. Article 17 of the Constitution of India deal with abolition of untouchability. Under which article of the Constitution untouchability is abolished and its practice is made punishable? Article 17. Which one of the following article of the Constitution provide the fundamental right, even right of private individual? Article 17. Which one of the following statement is incorrect? Which one is correct? Parliament can enact a legislation under Article 252 of the Constitution of India. State legislature cannot be enact legislature to punish a person for an offence under Article 17 of the Constitution of India, Parliament can enact legislation of electricity. An unlawful compulsory labor is deemed to be practice of untouchability when any person compel other person to do scavenging, removing any carcasses, sweeping. Which one of the following statement is not correct? No citizen of India shall accept a title from any foreign state. No title may be conferred. Fundamental freedom given under Article 19 of the Constitution are available only to citizens of India, where it is inoperative to show the requisite of respect of national anthem. Stand respectfully. In which one of the following cases it was held that the provision of the Chapter 8 of CRPC, being in public interest and not violative of Article 19 of the Constitution of India, Madhu Leme versus STM Monghari, freedom to speech and expression available to whom? Only citizen. In which case did the Supreme Court hold the freedom of speech and expression granted by Article 19 A includes the right of information? Secretary, Minister of the Information and Broadcasting versus Cricket Association of Bengal. Being a juristic person, a company is not a citizen. But in which one of the following cases Supreme Court held that if the state of action impaired the rights of the company, thereby affecting the right of the shareholder, protecting the Article 19 which available them? R.C. Cooper versus Union of India. Which one of the following article of the Constitution of India is related to liberty of press? Article 19. Right under Article 19 are available only to the citizen of India. Which one out of the following is not a fundamental right? Right to strike. Which article of the Constitution provides the right of freedom of speech and expression to the citizen of India? Article 19. Which one of the following is not within the jurisdiction of Right of Information Act? Rajiv Gandhi Foundation. Where any information sought under Right to Information Act concern the life and liberty of person, the same shall be provided within the receipt requisite of 48 hours. Which one of the following is not a ground on which reasonable restriction of the right of freedom of speech and expression is imposed? Public policy. Which one of the following is a ground on which state can impose reasonable restriction on the right of move freely throughout the territory of India? Protecting the interest of any scheduled tribe. In which of the following cases five judges constitutional bench observed that doctrine of postponement was aimed at the balance the right and accused to be presumed innocent till completion of trial with the media right of freedom and expression? Sahara India Real Estate Corporation Limited and others, Security and Exchange Board of India. Which one of under mentioned right is guaranteed to the civilization as right of freedom under Article 19? Right to assemble peaceful without arms. Which one is under mentioned right is guaranteed by the citizen of India as a freedom of Article 19 of the Constitution? Right to assemble peacefully without arms. The Supreme Court has held that right to fly the national flag with respect to dignity is a fundamental right. Every citizen within the meaning of Article 19(1)(a) of the Constitution of India in the case of Union of India versus Naveen Jindal. Right to form association under Article 19 Clause 3 of the Constitution include Right to collective bargaining. Which one of the following is a fundamental right? Right to form cooperative society. Which among the following is not a fundamental right? Right to strike. Which article of the Constitution of India guarantees citizen the right to settle in any part of the territory of India? Article 19(1)(e). Which one of the following cases is related to anti-strike verdict? T.K. Rangarajan versus Government of Tamil Nadu 2003. The fundamental right granted under Article 19(1)(a) does not include right to call and enforce band. Right to entertainment has been granted under Article 19(1)(a) of the Constitution of India. Article 1A, Article 19(1)(a) guarantee freedom of speech and expression all citizens of India. As per Article 19(1)(a) of the Constitution of India, all citizens shall have right to freedom of speech and expression. Which one among the following is not a ground of restrict freedom of speech? Law and order. In which case Supreme Court observed that there is no fundamental right to strike. T.K. Rangarajan versus State of Tamil Nadu 2003. Right to information is an essential part of Article 19(1)(a). The freedom of press in India is implied and right of freedom of expression. The fundamental right is available to the citizen only. Which fundamental right is available to the citizen only? Freedom of speech and expression. The number of categories of the freedom granted by Article 19 is A6. The state can make law imposing reasonable restriction on the right of citizen from association in the interest of sovereign integrity of the India. A right of citizen to carry on any occupation, trade, business is a constitutional right. Which of the fundamental right was amended by 97 Constitutional Amendment 2011, which got the President assent on 12 January 2012? Right of freedom. The freedom of speech and expression may be subject to reasonable restriction imposed by the law on the ground of contempt of court. The Constitution protection in Article 21, which protect the right of person in fair trial in law, a valid restriction operating on the right to free speech under Article 19(1)(a) by the virtue of force, it being constitutional provision, in which of the following cases the aforesaid observation was made by the Supreme Court? Sahara India Real Estate versus Security of Exchange Board of India. State may create a monopoly completely or partially with respect to Article 19(1)(g). Being a juristic person, a company is not a citizen. But in which one of the following cases Supreme Court held that if the state action empower the rights of the company, thereby affect the rights of the shareholder, the protection of Article 19 will available to him? R.C. Cooper versus Union of India. Right of information related to which article of the Constitution? Article 19. Fundamental freedom given under Article 19 of the Constitution are available only to citizens of India. The policemen in state formed one association with the member representing all cadre. The government amendment the rule allowing the formation association with member belonging to only one order for each association. The member challenged the validity of amendment rule. With regard to the above law, the following is correct. The amendment rule is valid as it imposes the reasonable restriction and right conferred under Article 19(1). The government imposes a ban on television channel broadcasting news, scene, story, communal right. The ban is challenged. Which one of the following is correct? The ban is valid as restrictions saved in clause 2 of section 19. An executive action taken during the national emergency in the violation of Article 19 of the Constitution cannot be challenged at all. Which one of the following statement with respect to right is known as correct? Right to know in India can traced to the Article 19 of the Constitution of India. Which one of the following is not expressly covered in the fundamental right under the Constitution of India? Right of freedom of press. Directive principles of state policy contained in the Constitution of India are relevant in determining the limit of reasonableness restriction laid down in Article 19 dealing with the fundamental right to freedom. On which one of the following freedom can reasonably restricted can be imposed on the ground of security of the state, speech and expression. In pamphlet invoking the render to join total violence struggle to bring about the revolution, the author is prosecuted for sedition under section 124A of IPC. The penal provision as the proceeding under are challenged by the author as a violation of his fundamental right and freedom of speech and expression. Is challenge legally tenable? No, because the provision is valid, as it is reasonable restriction on the freedom of speech and expression, and interest of the sovereignty and integrity of the India. Which one is under mentioned right is granted to the citizen right of freedom under Article 19, right to assemble peaceful without arms. According to which text of the Constitution, a reasonable restriction in interest of the sovereignty integrity of India can be imposed in the right to freedom of speech and expression. In which one of the following cases constitutionality of section 20 of Indian Evidence Act challenge for the violation of Article 20 clause 3 of the Constitution? State of Bombay versus Kathia Kalu, State of UP versus Devan Upadhyay. Actrophosis acquital is a principle related to double jeopardy. Which one of the following is the correct sequence of the protection in respect for the conviction of an offence? Ex post facto penal law, double jeopardy, self-incrimination. In which provision Article 20 clause 2? What is the provision Article 20 clause 2? Double jeopardy. That no person accused of an offence shall be compelled to witness against himself is an fundamental right. Which one of the following is the correct statement? Double jeopardy means putting the same person on trial twice for the same offence. No person shall be twice punished for an offence is incorporated in Article 20 clause 2. An accused person cannot be compelled to witness against himself. Which one of the following statement is correct? No one can be subjected to narco-analysis tests without his consent. The prohibition against the prosecution and punishment for the same offence more than once is contained in the Constitution of India. Contained. Which one of the following is not covered under Article 20 of the Constitution? Preventive detention, which is covered under Article 20 ex post facto law, double jeopardy, self-incrimination. Double jeopardy means No person shall be prosecuted and punished for the same offence more than once. Doctrine of double jeopardy under Article 20 Clause 2 of the Constitution of India means no one can be tried and punished more than one for the same offence. Protection in respect of the conviction for an offence is essential to which one of the following article of the Indian Constitution. Article 20. The protection of the Article 20 Clause 3 is available to confession of a guilt made to a friend who visits the accused who is in the police custody. Right against self-incrimination include right not to answer question exposing oneness to confession. Article 20 provides the protection against criminal liability, which is the correct language of Article 20 Clause 2. No person shall be prosecuted and punished for the same offence more than once. In which case the Supreme Court of India held polygraphy test conducted under the compulsion is a violation under Article 20 Clause 3 of the Constitution. Selvi versus State of Karnataka 2010. The doctrine against self-incrimination under Article 20 Clause 3 run to state that no person accused an offence shall be compelled to witness against himself with respect to above response of the following. Protection is against the self statement made in the compulsion. In which one of the following cases the Supreme Court of India has held the result obtained through involuntary administration of polygraphy examination and brain electrical activation profile BEAP test violation of Article 20 Clause 3 Selvi and others versus State of Karnataka. Which one of the following is not covered under Article 20 of the Constitution of India? Preventive detention. Which one of the following article of Constitution of India recognize doctrine of double jeopardy? Article 20 Clause 2. Narco analysis, polygraphy test and brain electrical activation profile test conducted against the will of a person subject to the test violate his right of the protection under Article 20 Clause 3. The right to the person liberty protected under Article 20 Clause Article 21 of the Constitution of India was held by the Supreme Court in which one of the following cases? Selvi and others versus State of Karnataka 2010. Article 20 Clause 3 states that no person accused of an offence shall be compelled to witness against himself. This applies to the case of narco analysis. As per the decision of Supreme Court of India, in which case Selvi versus State of Karnataka, compulsion using of narco-analysis, brain mapping and polygraphy test violatory of Article 20 Clause 3 of the Constitution of India. In Supreme Court in the Selvi and other versus State of Karnataka held that compulsory administration of narco-analysis technique to testimonial compulsion and their trigger and the protection of Article 20 Clause 3 of the Indian Constitution. No person shall be prosecuted and punished for the same offence more than once. No person accused of any offence shall be compelled to witness against himself. Article 20 of Constitution of India provided no person shall be prosecuted and punished for the offence more than one, same offence for more than one. No person is accused of an offence shall be compelled to be witness against himself. Consider the following statement. In the view of Article 20 Clause 3 of the Constitution of India, no person accused of an offence compelled to give oral testimony either in or out of the court. Ex post facto laws are laws which voided and punish an act that he had been lawful when done, imposing or increasing a penalty for retrospective effect. Violation of taxing statute does not infringe Article 20, Clause 1. The provision of Clause 3 of the Article 20 of the Constitution of India is not applicable to investigation proceeding. The law primarily comes with the judgment of the Supreme Court in which one of the following cases: Kathi Kalu Ojha versus State of Susrut. The judgment of the Supreme Court is Ratan Lal versus State of Punjab by application of Clause 1 of Article 20 of the Constitution of India hold that the said clause prevent the retrospective operation of only those criminal laws which are against the interest of the accused. An accused person can compel to give his fingerprints, participate in identification parade. Which one of the following pair is not correctly matched? Which one is correctly matched? Right to equality include primary principle of natural justice. Right of personal liberty includes right to livelihood. Protection against arrest and detention include right to consult and to be defended a legal practitioner of his choice. Which one of the following set is said to be the golden triangle of Indian Constitution? Article 14, 19 and 21. In the case of Unni Krishnan versus State of Andhra Pradesh deal with which one of the following right? Right to education. In which one of the following cases it was held that matrimonial rights are not violation of Article 14 and 21 of the Constitution? Saroj versus Surdarshan. In which provision of the Constitution spell right to clean environment as a fundamental right? Article 21. Ban on smoking at the public places is a violation of which one of the following of the article of the Constitution? Article 21. In which one of the following cases was held that telephone tapping is an invasion of right of privacy? People's Union for Civil Liberties versus Union of India. Which one of the following fundamental right cannot be suspended during emergency? Article 20 and 21. Article 14, 19 and 21. No watertight compartments rather than they are closely connected and executed. Enjoyment one other cannot be fulfilled was held in Maneka Gandhi versus Union of India. Telephone tapping would be infringe dash of the Constitution of India unless it is permitted under the procedure established by law. The court issued the guideline for exercising of power of the interception of the telegrams under Section 5 subclause 2 of Indian Telegraph Act 1885 in the year of 1997. Article 21. On proclamation of emergency under Article 352, the President has a power to suspend the fundamental right except the right secured in Article 20 and 21. Which one of the following is not included in the right of personal liberty? Right not to detain beyond 24 hours in the police custody. Which one of the following is not included in Article 21 of the Constitution of India? Right to die. Fair trial criminal cases granted in which Constitution of India? In the Constitution of India by which article? Article 21. In which one of the following cases the Supreme Court held that strike by lawyer is illegal and unethical and it infringes the fundamental right of litigation for speedy trial? Lily Thomas versus Union of India. In which one of the following cases it was held that by the Supreme Court that right to trade on the pavement is a fundamental right. Sodan Singh versus New Delhi Municipal Corporation Committee. Right to life does not include right to die. Was held in which of the following cases? Srimati Gilan Kaur versus State of Punjab. In which one of the following cases Supreme Court held that right to sleep is a fundamental right? In Re Ram Leela Maidan case.